Hello everybody, in this video we'll be talking about special corporations. In particular, we'll be answering what is an educational corporation and what is a religious organization. Educational corporations can be non-stock or stock corporations and are organized to provide facilities for teaching. On the other hand, religious corporations are composed of spiritual persons made for furtherance of religion and perpetuating rights or administration of the church. Educational corporations shall be governed by special laws and by general provisions of the Code. The Board of Trustees of an educational corporation. The Board of Trustees shall not be less than 5, and neither should they be more than 15. It should always be multiples of 5. 1/5 of the trustees will expire their term every year, and elections will be held to fill vacancies, unless otherwise stated in the Articles of Incorporation. Trustees elected after expiration of the term has a term of office of 5 years. Majority of trustees constitute a quorum, and institutions organized as stocks shall follow provisions on stock corporations.
Such religious leaders should file to the Commission the Articles of Incorporation, which should include the following: the applicant who desires to be a corporation sole, the rules and regulations which are consistent with becoming a corporation sole, that the applicant is charged with the management and administration of the temporalities, management of the affairs, properties, and estate of the religious entity. How any vacancy of the position in the corporation sole should be filled based on the rules and regulations of the religious denomination, sect, or church. The place where the principal office of the corporation is to be established and located, which should be within the Philippines. Any provision not contrary to law. And if the corporate term is not stated, it is assumed to have perpetual existence. The Articles of Incorporation must be verified by affidavit or affirmation by the religious leader with a copy of the commission, certificate of election, or letter of appointment of such religious leader duly certified by any notary public. After the fulfillment of the requirements, the said religious leader shall become a corporation sole, and all the properties and estate of the religious entities shall be personally held in trust as a corporation sole for the use, purpose, and exclusive benefit on behalf of the religious entities, including hospitals, schools, colleges, orphan asylums, parsonages, and cemeteries. A corporation sole can purchase and hold real estate and personal property for its church, charitable, benevolent, or educational purposes, and may also receive bequests or gifts. Such corporation may sell or mortgage real property held by obtaining order from the regional child court from where the property is located with a proof of notice published or directed by the court for the application for leave to sell it or mortgage. The application must be petitioned and duly verified by the religious leader, and it may be opposed by any member of the corporation sole, provided that if there are rules, regulations, and discipline presented by such corporation sole to regulate the method of acquiring, holding, selling, and mortgaging, it shall govern, and the intervention of the court is not necessary.
Anyone who succeeds a chief archbishop, bishop, or religious officer will be able to maintain the corporation sole status and will be allowed to transact business once they successfully submit proof of their ascendance into office, either proof of commission by other powers, certificate of election, or letters of appointment, duly certified by any notary public with the commission.
During the officer's vacancy, only the persons authorized by the rules and regulations of the particular religious denomination, sect, or church that the corporation sole represents are allowed to transact business, administer properties of the group, and exercise all related powers and authority.
The corporation sole may be dissolved voluntarily by submitting a verified declaration of dissolution, which includes the
the name of the corporation, the reason for dissolution and winding up, authorization of dissolution of the corporation by the particular religious denomination, and the names and addresses of the sponsors who will supervise the winding up. The corporation shall cease to exist upon approval and after winding up. Unless forbidden, the religious group may incorporate for the administration of its temporalities or for the management of its affairs, properties, and estate. After securing the affirmative vote of 2/3 of its members, they have to file the Articles of Incorporation verified by the affidavit of the presiding elder, secretary, clerk, or other member of the religious group, diocese, synod, or district organization of the religious denomination, sect, or church.